Hi, my name is Marck Joseph and I'm a South Florida family law attorney. And you're here to find out 5 things you need to know about family law appeals in Florida. Now, this is going to be an intense video, but before we begin, please like, subscribe, and hit the notification bell so you can be updated when we post new videos. So, this is a very exciting video for me because so many people have asked me to discuss this topic. And I'm not gonna lie, I was a little bit nervous about doing so because this topic is so important for people to understand when navigating family law matters in the state of Florida. So for background, an appeal is when you have a case or matter that is in the trial court, which is what we would consider the circuit court in a family law case. There are particular instances, which we'll go into a little bit, where if you do not like the decision that your judge makes, you can do what is called take an appeal of that judge. From there, it would go to what is called the District Court of Appeals, which is the appeal court, which depending on which circuit you're in, could be a certain number of district courts which would take the appeal on your case. That being said, I'm going to try my best to get you as much information as possible as it relates to appeals. And I know I'm starting with just 5, but if this is something that you guys want to hear more of, I might release a new video that discuss maybe more things about the appeal process so you all can have a better understanding of this process. The first thing I should note about appeals in the state of Florida for family law cases is that they are complicated. If you've seen any of my previous videos, a lot of times I will make reference to the fact of, in some cases, you can deal with a case on your own, pro se or otherwise. Appeals are one of those things that it is strongly advised that you get representation for. And this isn't regular representation because in my experience, there are a lot of family lawyers who do not take on appeals. This is how specialized and specific this base of knowledge is. The appeals court not only has a lot of the components of the family court in terms of determining what rules or laws and case laws being followed or not followed, there is its own rule of procedure in how you move an appeals court. Overall, the process is just different, and it's a lot more rigid than the trial court. The second thing you should know about family law appeals in the state of Florida is how you get to the appeals level. So, in its simplest form, you can appeal some non-final orders as well as final orders. But for purposes of this video right now, we're going to discuss the final orders. A final order tends to be considered when all the judicial labor on a case is completed. Now, you can't just file an appeal once that happens. There are specific rules in which you have to first file what is called a motion for rehearing, where you first have to ask the trial court to essentially reconsider their decision or ruling based on facts or laws or whatever is appropriate in your case. Now, I should note that this particular rule where I talk about the motion for rehearing, it was a little bit wonky up until earlier in 2022, where the Florida Supreme Court made it a uniform decision that before you can take a matter onto appeal, which is called preserving the issue on appeal, you have to file a motion for rehearing, where you first ask the trial court to reconsider the ruling that it made. And again, this is for the final order. The third thing you should know about family law appeals in the state of Florida is that you want to have a transcript or a record of what occurred in the lower court. What that essentially means is that if you want to challenge the decision that the trial court made, you really should have a court reporter at your final hearing so that you can get the final hearing transcribed. What the appeal court does is they look over the hearing as well as the docket of the case to see the history of the case and what happened at the final hearing, in which they would then determine whether or not there was what is called appealable error in the actions or decisions of the court. If you do not have a transcript of that hearing, you are only limited to possibly just the ruling and the final order that the court entered in the final judgment as part of your appeal. The biggest issue of doing this is that all the appeals court could see is what order the court entered. The appeals court would not be able to see what happened during the hearing. So if a lot of your argument for the appeals court is based on how the hearing was conducted, what evidence was introduced, what the person said, whether it should have been allowed, etc., you don't have a record of this, which makes it much more difficult to get a reversal on appeal. The fourth thing you should know about Florida family law appeals is that even though it goes to a higher court, it doesn't mean you actually get to speak and argue before that court. In fact, most appeals are done basically and only with briefs and reply briefs. Every once in a while, you might get a motion to extend time and possibly strike portions of briefs. However, all of this is done in writing. A person files a brief, the other party files possibly a reply brief, and then you may be able to file a reply to that reply brief. Most times, that's all you get in an appeals case. From there, the court, based on looking at those briefs, plus the transcript and the record as a whole, will essentially make their ruling. And from there, the court can either affirm some or all of the decisions or reverse some or all of the decisions. In very rare occasion, you can request what is called oral argument, in which you get an opportunity to argue your briefs or reply briefs before the appeals court. That being said, more likely than not, those requests tend to be denied. Now, the fifth thing you should know about Florida family law appeals is that this is how case law is created. Now, I've discussed it in previous videos, but what shapes family law as a whole is the statutes, the rules of procedure, or the family law rules of procedure and the laws associated with that, and case law. Case law is essentially the interpretation of the statute and those rules based on specific circumstances. So in other words, if you file an appeal on your case issue and the appeals court agrees with you, it will possibly write an opinion explaining the situation and the facts, explaining the law, and explaining how the court might have erred and what should have happened and why they feel that way. When you get that ruling, that now becomes binding, at least on any other case that comes out of your specific appeals circuit. So your situation, whether right or wrong, will now affect other families that may fall into the same situation or circumstance. Now, it should be noted, if you file an appeal, let's say in the 3rd District Court of Appeals, which includes Miami-Dade County, which is where my main office is, that doesn't mean that your decision will affect someone that's in Hillsborough County. However, the Hillsborough County Court can look at the case that happened here in the 3rd District, which is Miami, as maybe persuasive argument as to why if something happens to them over there, they should consider that as well. Long story short, the appeals process is how family law, outside of direct codification and statute, moves ahead. So, those are 5 things you need to know about Florida family law appeals. However, I will tell you right now, there is so much more that you'll need to know. So if you or someone you know are going through a family law or a family law appeals issue, feel free to contact our office. We can set you up with a consultation, give you some options, and let you know what we can do to help you. My name is Marck Joseph. Thank you for watching.